Mr. Speaker.
John Boscawen.
On behalf of the Honourable Rodney Hyde, the question to the Attorney-General.
Order.
What? Mr. Speaker, to the Attorney-General.
Order. Members have had their fun. We want to hear the question.
Thank you, Mr. Speaker. My question, rather the Rodney Hyde's question to the Attorney-General, why didn't he follow ACT's advice to repeal the Foreshore and Seabed Act 2004 and use Parliament's power to put iwi back to their pre-2004 legal position so Māori could have their day in court?
Honourable Chris Finlayson.
Mr. Speaker, two principal reasons. First, uncertainty about tests to determine customary title. In British Columbia, for example, certain Indigenous groups have been involved in litigation for years trying to work out the tests for customary title. The government thought it better to prescribe tests using the principles set out in the Ngāti Apa case and in common law. Secondly, uncertainty about what customary title is. The Court of Appeal in Ngāti Apa observed it could mean anything from use rights to exclusive ownership equivalent to fee simple. The government has provided certainty by setting out what rights may be conferred by a customary marine title order.
John Boscawen.
Supplementary, Mr. Speaker. Does the Attorney-General agree with the decision of the court in the Ngāti Apa case that, quote, any customary property in the areas vested seem unlikely to survive, end quote? If so, why is it under National's policy he stated publicly up to 10% or 2,000 kilometres of New Zealand's foreshore and seabed could end up in iwi hands?
The Honourable Chris Finlayson.
Actually, I don't think that what the court said was part of the holding or what they call the ratio. I think it was more an obiter comment. Nonetheless, I do agree with it.
The Honourable David Parker.
Wasn't the real reason that he didn't follow ACT's advice because he was annoyed and embarrassed by the loss of reputation his government has suffered as a result of Minister Hyde's lack of judgment and ACT's double standards?
The Honourable Chris Finlayson.
No, I was particularly interested in seeing a just result for iwi, a just and a durable solution, and the answers I gave to the primary question accurately and, if I may say so, admirably set out the position.
Supplementary, Mr. Speaker.
I believe the ACT Party has exhausted its questions.
Point of order, Mr. Speaker. I understand that we have an agreement with the National Party to have one of their supplementaries.
Order. Lucky everyone was out of order there. The honourable member be aware that if parties are to trade questions, which they are at liberty to do, they must advise the Speaker. We've received no advice that the National Party had allocated any questions to ACT today. ACT had a supplementary on question number 3 and a supplementary on question 12, and that is the full allocation. The member could seek leave if he wishes to...
Well, I'll seek leave to ask a further supplementary question, but my understanding was that an agreement had been reached and obviously understood that advice had been made.
Leave is sought for the member to have... Well, leave has been sought.
I'm just saying, I take your advice that ACT has expired with respect to questions and we have no objection to them.
Order.
Leave.
Leave is sought for the ACT Party for the supplementary question. Any objection? John Boscawen.
Thank you, Mr. Speaker. To the Attorney-General, why does he think it better that politicians like him determine the extent of iwi ownership of the foreshore and seabed guided by politics than the courts guided by the common law and facts of the case?
Honourable Chris Finlayson.
Well, it's not a question of preferring politicians like me to judges. A fact of litigation is that often it makes more sense for parties to reach agreement on something out of court rather than spend time and money engaged in the court system for years. That sort of thing happens all the time. Just a couple of months ago, after a High Court decision, when it was on its way to the Court of Appeal, the government entered into an agreement with certain trading banks over a tax issue. These sorts of things are not uncommon, and to characterise it as the member characterises it is silly.
The House comes now to questions to members.